Good afternoon, everybody. I'm really pleased to be here with you, and it's no platitude when I want to express my thanks and gratitude to Anna and Jarek for having me. It's my first time in Switzerland, at least not for business related matters, not skiing. So I'm really happy. I'm also wandering the view, and I'm hoping for at least one ship to pass by so that we would be a little bit more in the law of the sea, not necessarily marine biodiversity, but at least law of the sea mood. I'm really thankful. And yes, indeed, I want to navigate you through the waters of marine biodiversity and the new treaty and its dispute resolution mechanism. So the treaty, as that treaty entered into force less than 3 weeks ago, so it's topical. It was concluded. The negotiations thereof concluded in 2023, entered into force just now. But I also am cautious of the fact that you come from different backgrounds, you have different career paths and objectives, and you're not necessarily familiar with the law of the sea. So I will attempt to navigate these waters in a sort of cautious manner. So I'll try to introduce fairly descriptively what is this BBNJ treaty. And then share some words on its dispute settlement mechanism, and I hope this will be of interest to you. Last two disclaimers. One disclaimer is obviously all views are personal and not to be attributed to the tribunal. And lastly, I'm looking forward to Q&A sessions. So this is my intended structure. Essentially, I want to cover three things. So first, I want to focus and draw your attention to the BBNJ Agreement, what it is, what it does, and consequently, which is important for me, what disputes could arise. I'm not really in the job of devising disputes and rather try to solve them. So but I'll leave it to your imagination a little bit as well. What types of disputes you might have. Because to me, talking in the abstract about dispute settlement mechanism without the context, without what these disputes would be about, would be a little futile. So I want to spend quite a bit of my time on this first part. So not the actual dispute resolution mechanism, but what this mechanism could apply to. Secondly, I will very briefly run through some general aspects of the dispute resolution mechanism under UNCLOS. Here, I'll rely on excellent teaching skills of Anna. You had a lecture the other day on this, so I will just treat it as a reminder rather than re-lecturing you on UNCLOS. And then lastly, I'll take you to BBNJ. Here's the ship. Yes, fine, very good. As discussed, right on time. This is my intended plan. I hoped Anna will actually decrypt BBNJ, which will save me 5 minutes of my talk, but she didn't, so I'll do it. So. This is the BBNJ, since it's the Agreement on the Conservation and Sustainable Use of Marine Biological Diversity in Areas Beyond National Jurisdiction. So biological diversity in areas beyond national jurisdiction, BBNJ. And I'll use that acronym throughout, so bear with me. So what is this cute and mysterious creature, the BBNJ Agreement? So let me start. I like this graph. I don't necessarily agree with all the nitty-gritty description of it, but hopefully you can't see it all. But to me, it's good, and it's well describes the motto I also like, which is how inappropriate it is to call this planet Earth, since it's really an ocean, and that shows it quite well, I think. And if you see, and I believe you can, yes, you can, this darker blue is actually areas beyond national jurisdiction. So around 70+% of planet's surface is ocean, and around 40+% of it is areas, marine areas beyond national jurisdiction. And if you were to look at the same slide or graph, well, except the landmass, but through juridical lens, you could see this, which is essentially table of contents of UNCLOS, UN Convention on the Law of the Sea. And what you would be able to observe is this, on the left-hand side at least, is this so-called zonal approach. So UNCLOS will, the large part of UNCLOS will actually take you through various maritime zones from the coastline, or in proper legal parlance, from the baselines, through territorial sea up until the high seas and the area which you have marked, which I marked in orange, which are the two zones that are outside national jurisdiction. In the other zones, states either have sovereignty or sovereign rights or jurisdiction. We're not going to discuss this. And it's not really the topic of BBNJ agreement. But the BBNJ agreement is about areas beyond national jurisdiction, and there are two such zones, high seas and the area. On the other hand, obviously, UNCLOS does not put a full stop after describing various zones and ascribing various powers of states and freedoms to states in these zones. So there are some horizontal aspects to UNCLOS as well. To me, from the perspective of BBNJ treaty, perhaps the holistic and horizontal comprehensive part 12 on the protection and preservation of marine environment is perhaps particularly relevant. And I'm pointing to that also to underline that BBNJ is not completely in the abstract. It's there are some rules there. There had been some rules there before UNCLOS, perhaps not specific, perhaps not detailed, but there was something out there, such as the rules concerning the preservation of marine environment, but also marine scientific research, actually, which is not highlighted, or transfer of technology and of marine technology and capacity building provisions in Part 14, which is also not highlighted, are also pertinent to BBNJ agreement. And lastly, which is highlighted, it's the settlement of disputes. So the famous Part 15, well, famous at least for international lawyers, and including the law of the sea lawyers, the Part 15 of UNCLOS dealing with the dispute settlement. So now, when I have you here, so why, if there's so much of UNCLOS out there, there is so much law of the sea, so why did the negotiations of BBNJ start? Why was it necessary? And it's not, NASA had nothing to do with it, at least as far as I know. But I do like to juxtapose these two pictures. So 1969, landing on the moon, and 1979, which is 10 years later, obviously, but which is the famous Woods Hole Oceanographic Institution, US-based institution of Alvin, submersible. And what they did actually in 77, so there was another expedition 2 years prior to that, but they didn't have biologists on board because they were doing deep dives into the deep ocean and no one expected life to be there. It's, a desert. It was expected to be desert-like. So they had geologists and all that, and that sort of scientists, but not necessarily biologists. So it took them 2 years to mount another expedition, 79, where they actually had biologists because they have discovered hydrothermal vents, ecosystems, or black smokers. You can see a picture of a black smoker there. So these would be the high temperature mineral rich vents. This particular one is Pacific Rise. And it was a major scientific discovery. Actually, it's considered one of the greatest in the 20th century. Why? Well, because how these organisms operate is not on the basis of photosynthesis, but chemosynthesis. So they produce organic carbon based on chemicals, not light, as energy. And actually, if you're interested, there was a nice documentary by National Geographic called Dive to the Edge of Creation. And it's actually a little bit of telling title of this documentary, because it was considered that those ecosystems may give us a glimpse into how the origins of life perhaps started on Earth, or maybe even beyond Earth. How ecosystems can thrive without light, without sun energy. And so that brings me to this far right end of the slide. So where's the irony, or the deepest of ironies, which is, I'm borrowing this from the article by Lyle Glovka in 1996. So where is that deep irony in all of it? Well, you have UNCLOS, you have 320 articles of UNCLOS, plus annexes, and plus implementing agreements, actually. And you have 60 of those articles devoted to the area. If you recall, one of those zones beyond national jurisdiction, high seas, and I'm going to simplify now, so don't quote me on that, sort of water column, and the area, meaning the seabed and subsoil thereof in areas beyond national jurisdiction. So that actually is a little bit more complicated. I mean, the relationship between the high seas and the area is not that clear-cut as I just stated, but for the purposes of this talk, let it suffice. So the area, and these 60 articles of the whole UNCLOS are devoted to regulating and governing the regime of the area. Primarily calling it the common heritage of mankind, creating a special institution, International Seabed Authority, which with the seat in Kingston, Jamaica, to act on behalf of the humankind, primarily to deal with the minerals of the deep seabed. There's actually a bit of argument whether that's solely the common heritage of mankind, whether that's solely about the minerals or not, but let's say for the purpose of this argument, so you have these regulations that actually go back to another famous speech of 1967 by Arvid Pardo, Maltese ambassador, that sort of launched the idea at the United Nations that, you know, there are this incredibly rich and vast reservoirs of precious minerals lying on the deep seabed. Potentially, you know, back then there was no area, so they're like high seas, so there's a freedom for all. And his claim was, you know, it's not fair since these areas, since these minerals are beyond national jurisdiction, so they belong to no one, but also to everyone. And it would be not fair if only the technologically advanced would you know, take advantage of these minerals. So let us have a new treaty that would govern these resources. And that was one of the main reasons why the UNCLOS negotiations started, and why you have such a robust regime in UNCLOS pertaining to the area and its mineral resources. Going back to the irony, that exploration took place, but exploitation of these minerals still was, now it may be changing now actually, but certainly in the sort of late 90s of the 20th century and early 20th century, that was still a moving target to be able to viably explore these minerals. So you would have this robust regime for the activity that didn't fully take place. But in the meantime, what you started seeing was so-called bioprospecting, which could be called as a search for viable mineral compounds, biological compounds. Useful scientifically, commercially maybe. So that activity actually took place. But the realization came, and that was this deepest of ironies, that the UNCLOS governs the activities that is not really take place, but fails to fully address the activity that is actually taking place. I simplified a little bit, but you see the point about the deepest of ironies I'm trying to make. So that was one, that was not the sole reason, but that was one of the reasons, one of the main, maybe even reasons, that the realization come in the early, let's say, 21st century, beginning of 21st century, that we should have some new regulations in place. And I'm deliberately using the word regulations, not necessarily a treaty, because at the beginning it was far from obvious that the treaty would be actually the end product of all of this. But for different reasons, many agreed, yes, we should have something dealing with that biodiversity in areas beyond national jurisdiction, including for what I've described, thanks to these slides. And now, let me show you also a little bit historically. So this is the package that was agreed later on in 2011, but it shows you, let's say, it's nice to, I think, draw your attention at the beginning, which is the four main elements of the finally negotiated treaty, and a little bit four main reasons why the treaty negotiations started. So you do see marine genetic resources, including questions on the sharing of benefits. You see the echoes of this common heritage of mankind and then the sharing approach. But also, again, simplifying a little bit, you would have two more marine conservation, bit more oriented parts of this 211 package, which is environmental impact assessments, area-based management tools, including creation of marine protected areas, and then two more sustainable development-oriented marine genetic resources, capacity building, and transfer of marine technology. So you could imagine that different states, different groupings of states have different sort of priorities in mind, but overall, most of UN collective, if I may put it this way, was in favor of starting at the beginning new process that later translated into negotiations that later translated into actual BBNJ treaty being adopted and enter into force. I will not do justice to the BBNJ treaty as a whole. One scholar commented that it's actually 4 treaties in one. And there is something to it because this is also a little bit the structure of the treaty. So you have separate parts of the treaty and they're also from the treaty law perspective, pretty autonomous in a sense. Obviously, they're bound together by cross-cutting issues. Some of them are like classical treaty stuff, preamble, final clauses, all that. But also, importantly for us, it's also dispute settlement mechanism. So that's the kind of like a fifth topic of or cluster of issues. So just to show you this, I will not take you through the nitty-gritty of negotiations. I just want to show you it took quite a bit of time. So the first meetings started in 2006, and I was lucky to be there in the United Nations, and lasted and transformed through various phases and stages of these negotiations. Actually, back then, not negotiations, but sort of working group level. Then, importantly, in 2011, this package of issues, so how to translate that marine biological diversity, it was translated into those 4 main components of negotiations: marine genetic resources, marine protected areas, environmental impact assessment, capacity building, to simplify. And then only in 2015, a decision was taken that actually the end product would be a treaty. And actually that it will be under United Nations Convention on the Law of the Sea, which was again at the inception of these debates far from obvious, because some said, well, actually we have another treaty, Convention on Biological Diversity, which is perhaps not Law of the Sea treaty, but it's better apt in addressing biodiversity, as the name suggests. Suffice it to say that UNCLOS, being the product essentially of the 70s, because that was a large chunk of UNCLOS rules negotiated in the 1970s, doesn't even use the name such as biodiversity, marine genetic resources, on any of that. Anyway, decision was taken, final treaty under UNCLOS should be the end product. And that took us till 2023. Also, the pandemic and the COVID delayed the negotiations a bit, but ultimately, we had a success. It was termed as historic landmark and the triumph of multilateralism, bringing to the UNCLOS family of treaties the third implementing agreement. So you see, and then you probably saw through the lecture of Anna that there's a 1982 United Nations Convention on the Law of the Sea, stemming from 82, but that negotiations began in the 70s and it entered into force in 1994. So this is the time span of UNCLOS, right? And you additionally have the 1994 implementing agreement, 1995 implementing agreement concerning fisheries or types of fisheries, and finally 2023 BBNJ agreement. So this is the sort of UNCLOS family. Let's put it this way. One point one takeaway from this slide I want to have is the legal relationship of these agreements with UNCLOS is different. So, for example, the 1994 implementing agreement is so intimately connected, legally connected with UNCLOS that you cannot be a party to one without being a party to the other. It's just, the both of them you need to ratify. However, with UN Fish Stocks Agreement, the 1995, and the BBNJ Agreement, you actually can become a party to these treaties while not being a party to the mother treaty, to UNCLOS, which is important also for the dispute settlement mechanism. So that's why I want to draw your attention to this one. And it was certainly important for the negotiations of this dispute settlement mechanism. I will now briefly discuss three subtopics of the BBNJ treaty, but I will do it in a relatively light touch manner, I would say. So as to the MGRs, one thing I wanted to draw your attention to that, and probably already know it from my initial description about the Alvin expedition. So we're not now talking about certainly different type of activity than fishing, right? In fishing, you're interested in the quantity of the material. So the more you harvest, the better, in simplified terms. But now what happened with these resources is that it's not the quantity that matters normally, it's the quality of the material you will find. Obviously, the argument being, since these organisms are so unique, they are living 2, 3, 5, 7,000 meters below sea level, no sunlight, huge pressures, it's either extremely cold or extremely hot. If these organisms thrive there, they must exhibit some unique properties, including genetic properties. And if they're so unique, they're scientifically interesting and maybe even commercially viable. And maybe there might be some utilization out of it, and maybe even some commercialization of products out of it. And if yes, then you're looking at these organisms as samples, and also you're looking at them not only as samples, but which happened actually throughout the negotiations, which was a very interesting shift in negotiations, because the realization came how you actually do science nowadays. And well, part of it is through mining or the databases from your office here, without leaving your office, even less embarking on a ship. And you're interested in the digital sequence information. So you're interested not really in the sample. Many scientists would not even touch the sample from the deep sea. They would be interested in the digital description of the DNA or whatever else in their computer. That's it, because they're searching for some interesting property they are willing to work on. And if that's the case, then the whole scheme needed to be different. And that's why, for example, in the NGR's part, what the BBNJ agreement does is it sets out, let's say, pre-collection and post-collection obligations. So what you do before you go out in the sea, and this is perhaps less important, but you need to, let's say, notify the central clearinghouse mechanism that you're going to do that sort of work. And then, however technical and non-interesting that might sound, a unique BBNJ standardized identifier will be ascribed to all the samples and data derived from that cruise. And why this is important? Because if you want then any obligations to be attached to the usage of these samples or data deriving from that, they need to have a tag, the BBNJ tag, that it comes from areas beyond national jurisdiction, and there are some different obligations attaching to it. And this is what this BBNJ identifier is how it's supposed to operate. So it's actually quite crucial for the whole mechanism. And then you have post-collection obligations from pretty simple reporting obligations. Also, you need to notify in which database or in which repository your sample or data is stored. So there will be no central data or repository at the UN level that you have to bring your samples or data. But you have to send information where that data is. And it needs to be publicly available because it's from areas beyond national jurisdiction. So it kind of belongs to everybody, again, to simplify. And then everybody can use it. And then there may be some additional obligations if you utilize it and maybe in the long run you commercialize it, there might be some additional obligations applying. So it's a sort of long process, both in physical terms, but also legal terms. It's a process. Now, about ABMTs and so area-based management on marine protected areas, I'm not going to talk for long. It's just I'm going to show you again. BBNJ agreement it describes a process, and because these are areas beyond national jurisdiction, so there is no one competent state or another body that would be competent to govern these areas. There are some sectoral organizations. You have International Seabed Authority, you have international maritime organizations, you have regional fisheries treaty arrangements, and so on and so forth. But there is no global overarching comprehensive organization that would be entitled to set up, okay, here we will carve out this portion of the ocean and we'll do ocean sanctuary there, or whatever else. And there will be restrictions to fishing, and there will be not only scientific available for scientific usage, for example. So it was not really possible, or it was possible, but in a sectoral manner, a little bit under IMO, a little bit under RSA, and so on and so forth. So what the BBNJ tried to do is to create some common denominator criteria, how and when and what would be the process to establish such areas. And crucially, at the end, this is why I highlighted the COP, the Conference of Parties established under the BBNJ, would be entitled to take actually some decisions, either to establish some such areas or establish measures compatible with those already existing, or if there is actually another organization in place, to recommend to that organization, could you please do this and that because we feel it's important from the BBNJ sort of perspective. I'm not going to develop this thought much longer, but for those of you that may be a bit familiar with it, that rings a bell of a famous not undermine clause that it's a very vibrant in BBNJ treaty, which is the BBNJ treaty cannot undermine other treaties. And there's a whole scholarly and practical and political debate what that not undermine would mean. But essentially BBNJ will need to find a way of doing something meaningful without undermining the competences of other already existing bodies and their competences. So that's why this decision-making is either shall take decision or may take decision or may recommend to other body to take some measures, so depending on the sort of setup. In terms of environmental impact assessments, if you're not aware of that tool, it's essentially procedural tool. So it's a process that allows you to establish whether the activity as a state you're going to authorize will or will not be harmful to environments, to simplify. And ultimately, you're able to take one or the other decision in any way, but you need to go through the process of trying to identify what are the stressors for the environment, and what your proposed planned activity will add to that. And it allows you to assess it. So there's, again, a process, but at the end of that process is a state decision which may still authorize it, notwithstanding sort of the whole process. But it will involve other states here. So it's actually, I think, the longest part of BBNJ. It's pretty procedural. But this is just to show you that all of both in terms of establishment of marine protected areas and EIAs, these are processes involving all stakeholders, including in particular states parties to the BBNJ Agreement. And now that will close the first part of my talk. So this is, what's the BBNJ? Now, this is my reminder of the UNCLOS dispute settlement scheme, which was considered this famous pivot upon which the delicate equilibrium of compromise reached in the negotiations of UNCLOS must be balanced. So it's a little bit jewel in a crown. You probably already know that it's not very not typical for the public international law that there would be a binding compulsory dispute settlement mechanism. Here we have it. And this is it. This is the whole part 15 in one slide. So you have general obligations. It's actually a mixture of various types of obligations. Some of them are very simple, like obligation to settle your disputes in a peaceful manner, which is sort of United Nations chartered enshrined obligation, to more nuanced ones, such as the one in 281, which is that the parties may agree in another treaty for a different dispute settlement scheme, but I'll go back to that later on. And then the famous Section 2 says that any dispute that is not solved by recourse to Section 1 may be and at the request of any party. So then you do not require the consent of the other party, because any party of a dispute may direct a dispute to the court or tribunal having jurisdiction under Part 15 of UNCLOS. And these are these courts or tribunals having jurisdiction under UNCLOS. The famous cafeteria approach. So you have a menu of options of coffees you can choose from. The only sort of difference with the standard walk-in coffee place you have is that once you walk in that treaty, if you don't choose anything, you will leave with Annex 7 coffee. This is your default drink you're having. Unless you choose something else. If you choose ITLOS, perfect. If you choose ICJ, perfect. If you don't choose anything, or Anna will choose ICJ and I choose ITLOS, as it happened, ultimately we all have chosen Annex 7 arbitration, because that's the lowest common denominator we have, right? So this is how this famous Montreux formula, actually 2 hours, I think, ago from here, where there was a Geneva session of negotiations of UNCLOS, and they had a retreat to Montreux, and Professor Riephagen of the Netherlands sort of devised that formula, which is, as many times in international law, a compromise among many options. Those that felt standing ICJ already existing, obviously, at that time would suffice. Others would be saying it's a so specific treaty, we need a specialized, tailored institution, ITLOS. And others would say we don't need any of that. We just need ad hoc arbitration, and we'll, consent whenever needed. And ultimately, you have all of it. This is how it works. But you also have limitations to it, either operating straight from UNCLOS, so you don't have to do anything as a state. So these are, from the BBNJ perspective, I would guess not really interesting to us, because they're primarily relating to discretionary powers of state in their sort of areas under sovereignty or sovereign rights. But there are optional exceptions, so states can actually choose, when they ratify UNCLOS, to carve out particular types of disputes, 3 in particular. So disputes concerning boundary delimitations, marine boundary delimitations, disputes concerning military activities, and disputes where United Nations Security Council is seized of. Perhaps that middle one would be, if anything, most relevant to BBNJ, but I'll tell you what I'm mentioning. Generally, some 56 states made declarations under UNCLOS. So 1/3, there's 171 parties to UNCLOS and 56 declarations, which also means that roughly 2/3 of UNCLOS parties chose nothing. I mean, they chose none of these. And Annex 7 arbitration would apply unless, which I know also Anna mentioned to you, unless those parties that are already engaged in Annex 7 arbitration will agree to transfer the dispute, which they did on a number of times, to the tribunal. Okay, so that was a reminder of UNCLOS. Now BBNJ. So first, it was a bit of a bumpy road to negotiate BBNJ dispute settlement mechanism, and it was one of those thorny issues. But again, to simplify, there were 2 main approaches. So either to somehow utilize the UNCLOS mechanism, since it's UNCLOS implementing agreement, it would make sense to sort of preserve the unity of settling disputes, or to have something completely new. There were some states preferring that approach. And among that first group, so the one that, let's keep UNCLOS approach, there were 2 subgroups. One subgroup would be UNCLOS states parties. For them, it was only natural that they will copy-paste UNCLOS dispute settlement mechanism. But there were also, this is why I highlighted, non-parties to UNCLOS that could be parties to BBNJ. And they were concerned that if, for example, the first proposal during the negotiations was that Part 15 of UNCLOS will apply mutatis mutandis to BBNJ, which is actually the very approach that the 1995 implementing agreement utilizes. But those parties were concerned that that would somehow mean that the UNCLOS applies to them. And for various political and legal reasons, those countries didn't like that. So after many iterations and approaches at solving that, so having UNCLOS but not implying that UNCLOS as a whole would apply to those BBNJ parties that are not parties to UNCLOS, the final language was that this dispute settlement mechanism shall be deemed to be replicated for them. That's the quote-unquote language. And this is the BBNJ dispute settlement scheme. So first, you have, again, a various set of obligations. You do have general obligations, just as I showed you on the left-hand side of UNCLOS. And it's interesting, at least for a lawyer, if you were, we don't have time today, but if you were to read through this in a very detailed manner, as even though the whole of Part 15 of UNCLOS is copy-pasted or deemed to be replicated for the purposes of BBNJ, some UNCLOS obligations are still repeated, such as general obligations, like the obligation to settle disputes by peaceful means, or that parties may agree at any peaceful chosen by them. Then there is another provision of disputes of technical nature, whatever that would mean. That's actually copy-pasted from the 1995 fish stocks agreement. UNCLOS doesn't have that solution, and BBNJ has that you could have disputes of technical nature, and then you would have experts, and it would be like a non-legally binding result. Although there is, even though it's copy-pasted from the 1995 agreement, there is actually no precedent of the practical usage of that mechanism. So it's a little bit, but it's still, it was deemed appropriate to have it in BBNJ agreement. And the jewel in the crown is this Article 60, which is, as I mentioned, for those BBNJ parties that are also UNCLOS parties, the whole Part 15 applies directly. So the whole of what Anna talked to you about, and I briefly, a few moments ago, all of that applies to BBNJ. And for those BBNJ parties that are not parties to UNCLOS, that Part 15 is deemed to be replicated, the whole of it. And then finally, you have the semi-innovation, which is advisory opinions. Why is it an innovation? Well, because UNCLOS doesn't really say, at least not directly, that UNCLOS has advisory jurisdiction. It only has that sea disputes chamber, the one dealing with the area and the seabed, has advisory competence. And that question was controversial. In 2013, when the first advisory request was directed to the tribunal, that was very controversial. The tribunal said it has advisory jurisdiction. It repeated that not so long ago when it issued its second advisory opinion on climate change. But here it is at least directly stated that the tribunal would have advisory opinion jurisdiction. However, it is a slimmed down version of advisory jurisdiction as compared to the initial proposal, which was rather all-encompassing on any legal question pertaining to BBNJ. Here, what you see in the final version is much more restricted, and it's just on the the COP, the Conference of Parties, may ask ITLOS to give advisory opinion on legal question on the conformity with this agreement of a proposal before the COP. So it's a slimmed down, pretty narrow version of the original idea about advisory opinion and the scope of it. Still, it is there. So where does this take us? Well, one, we have a mix of various jurisdictional limitations and carve-outs in BBNJ, because one, if it copy-pastes UNCLOS, then it means that those limitations and exclusions of UNCLOS apply to BBNJ as well. So that's one, even though most of them arguably are not really suited for areas beyond national jurisdiction, still maybe some, who knows. Then you have Part 9 of BBNJ dealing with dispute settlement mechanism, and it has additional more carve-outs than UNCLOS envisages. I would draw your attention to two, which is that this is without prejudice to dispute settlement procedures agreed in relevant framework and bodies as to their interpretation. So the BBNJ system is without prejudice to other systems. So it's actually interesting whether that encompasses UNCLOS itself. So does this excludes UNCLOS, particularly if you bear in mind that some disputes may be of a mixed nature. So they may involve BBNJ and UNCLOS. It's easy to conceive, particularly bearing in mind the horizontal overarching environmental provisions of UNCLOS. It's not so abstract. And also, which is an echo, arguably, of some arbitrations the world has seen in the recent times, that there is a very specific carve-out that whatever the dispute settlement would deal with, it shall not deal with the legal status of an area within national jurisdiction. So it may not address an issue dispute which concerns, which is relatively broad term, or necessarily involves a concurrent consideration of the legal status of an area as within national jurisdiction. So that's for those of you that follow law of the sea, you might guess which types of disputes that refers to. And finally, there's a general exception in BBNJ that it doesn't apply to warships, except for the part dealing with MGRs, so there's a bit of a ping pong, which I will not ping pong with you now, but it's pretty complicated. But my point being that there's a mixture of carves out and limitations here. So finally, when it comes to the choice of forum, and I'm ending with this one. So you have, for UNCLOS parties, their choice as to which forum will be their dispute settlement forum, that choice stays. So for that 50 plus parties that declared, unless they change it for BBNJ, that stays. Having said that, at least 3 parties, as I've noted, Chile, Greece, and Trinidad and Tobago, actually reaffirmed their declarations of UNCLOS, even though I guess legally it's not necessarily needed, but they did so. For UNCLOS non-state parties that become parties to BBNJ, they make new declarations. For the time being, I think no party did that, except Turkey, but the Turkey only declared optional carve-outs of jurisdiction, but they didn't declare any forum, dispute settlement forum, which would mean that, again, the default would be Annex 7 arbitration. And then let me take the 2 middle ones at once. So all of it, I hope I convinced you, or I showed you that it's an interesting interplay in between UNCLOS and BBNJ agreement as to which forum shall apply, which exceptions or limitations will apply, and particularly when it comes to mixed disputes, so those involving UNCLOS and BBNJ, which dispute settlement mechanism will actually be triggered, and how and which provisions will come into play. And then finally, my last point. Sorry. It's interesting to see sort of the old system, dispute settlement old. It's not that old, but still. The UNCLOS system to be applied to BBNJ, which was considered to be quite a big victory. It was not an obvious result, and it's nice, certainly from my perspective, it's heartening to see that this jewel in the crown of dispute settlement, which is this UNCLOS system, was preserved into BBNJ. But on the other hand, it's interesting to see that you have this old system, but a completely new treaty. And it's presenting you with a completely novel law of the sea, maybe even going beyond the law of the sea, traditionally speaking, questions, and how this old system, with people behind it, such as myself potentially, how it will deal with those novel questions in that old system. So that's interesting. I would say the tribunal is prepared, obviously, but still, it's when you go through it, and that's why I took so much time in sort of trying to show you. It's quite a novel treaty. Not necessarily classical law of the sea questions are posed and potential disputes arising, maybe of a novel type as well. It's interesting to see that there is limited but still confirmed jurisdiction advisory competence of the tribunal. And it's actually, this is something I thought of on my way here, and I'm not, let's say, 100% sure, but it's unclear to me, even though this system, Part 15, was replicated for BBNJ, for UNCLOS non-state parties. I'm curious whether they will be entitled to nominate their Annex 7 arbiters, because there is no such express provision in BBNJ, and there is such a provision in Fish Stocks Agreement. But we'll see what the future brings. And yeah, with that, thank you.